Let's stay with the story and speak to legal analyst Mpumelelo Zikalala. Kuzen, thank you so much for your time this evening. Judge Pitkun saying that he doesn't believe the substance to this particular application. He's doubting whether or not there is a chance that it may succeed, but he has no choice because there are legal grounds for this. In your view, what are the chances of success?
I'll still hold the view and then align myself with Judge Pitkun and say they are very slim. Unless the court is going to say, we want to expand the definition of title to prosecute to include the conduct of the prosecutor and say, in what circumstances would the prosecutor not be allowed to prosecute? Even if the prosecutor, in this case, Adv Billy Downer, is found not to have title. But I don't think it's going to have the effect or the repercussions of making the case go away. So even if you could be removed on extreme basis, maybe upon another argument being submitted, it is not going to have the effect of wishing away these particular charges against the former president. So I don't think it's going to achieve the ultimate goal in which the former president would have wanted. Even if the matter would go to the court, it will still come back to the same conclusion. But I think in this case, Judge Pitkun was simply saying, my hands are tied. There's simply nothing I can do because it's up to the SA to decide on this matter. You could even see with his demeanor and body language that he was saying, this particular court, the SCA in this case, is usually very efficient when it comes to matters. I do not understand why they are delaying in deciding this particular one. However, let's give them the benefit of the doubt. In doing so, I'm going to apply my duty as a presiding officer, uphold the rights of the accused, in this case, it's Section 35, and make sure that everything moves swiftly. The trial is able to start and end within the shortest amount of time, but at the same time, investigate the reasons for the delay, which is why I want to put everyone on tape and make sure that their diaries are clear for when we come back from on the 1st of August.
Could there ever be a time when we see the law being tested, though, on the extension of, the title to prosecute, to include the prosecutor's conduct? Do you think that is something that the law may be tested to do?
I think it will. There are certain boundaries in which maybe we haven't reached in terms of determining that title to prosecute. However, what we have currently, or what the law says, it then says, if you feel that the prosecutor extended its bounds in terms of what can and cannot be prosecuted and the conduct of the prosecutor, what you should do is to highlight those instances of the inconsistency with the conduct of a proper or a reasonable prosecutor in this case during the particular trial. And at the end, you're going to highlight all those things so that it is easier for you to prove that the manner and the procedure that was followed in managing this particular trial, the manner in collecting the evidence in this particular trial has been that which is irregular and cannot be accepted by our law. If you have been able to do that, then it's easier for you to prove that the way in which I've been tried, the way in which I've been prosecuted is not a way in which is consistent with my rights as per Section 35. On that basis, I should be acquitted due to the contravention of my rights. Now, what Judge Pitkun was saying when he delivered his judgments earlier in the year, he was saying there are precautionary measures, there are things which have been put into place which allow you to make those determinations. It is not for me to make that determination now when there are other substances and other systems that you can use to come to that determination. Rather use those instead of going the shorter route of saying this person does not have title to prosecute and it ends there. Linked to that is this. Let's remember that the merits of the matter are also important. The merits in this case simply saying we want to make sure and check, is this person guilty or this person innocent? We do not want a person to be let out purely on technicalities just because someone didn't do their job in a proper manner. So the way in which all those instances will be highlighted will be during the trial. So what Judge Pitkun was saying was, don't allege those things now. Make sure that during the trial you are able to highlight them and keep on highlighting them to me, and I'll be able to make a determination whether the manner in which we've arrived at court, the manner in which the evidence is collected, the manner in which the prosecution has conducted itself is not right, and then I'll be able to acquit you if that's indeed that's the case.
The judge also saying that he's concerned about the delays, and not only in the demonstration of justice, but he also says on the part of the accused, particularly, the accused number 2 in this matter, and which, of course, we do know that is Thales. I wonder, in your view, what are these delays? What impact could they be having on this particular case, if at all?
Let's remember that accused number 2 is a business, so reputation is one of those things in which they trade in. It forms core part of their business structure. So if you are going to be an entity which is going to court for the past 8 years or the past few years, nobody is going to want to trade with you. The second part of the privileges that may be suffered or is suffered by accused number 2 is that of cost. So each time you see Advocate Periru and other advocates and legal practitioners at court, we must know that they are being paid. Now, if you go to court and you literally say whatever that you need to say to the court in less than 2 minutes, it means that accused number 2 continues to incur this cost and at a delay which are not occasioned by them. I must mention, though, that these particular delays are necessary because it is the exercising of the rights of the accused that must be protected at all times. So you cannot say, due to exercising of your rights, we are going to trample on them, because it's a time factor, it's a money factor. It's one of those unfortunate things that we have to go through. However, the presiding officer, in this case, Judge Kun, that is why he's more particular as to the instances of delay. He wants to find out what is causing these delays, who's to blame, how can we eliminate them. Hence, he's making sure that there's no time in which we are going to leave the Pietermaritzburg High Court without a definite date and without an oral submission of saying, what seems to be the hold-up, let me check what is happening. In this case, I think he fell short of saying, I do not understand why the SCA is not making this decision. He should have made it a long time ago. I think he was protecting himself and respecting the decision and authority and the autonomy of the SCA by saying, I'll leave it to the SCA hands. However, I must mention that I'm a bit disappointed when it comes to the manner in which they've handled this matter.
It's going to be interesting how it unfolds, especially because he says that if the trial is not ready or there's still quite a lot of ongoing matters there, they will announce a new holding date. There's now even talk of private prosecution. There's now talk of potentially going to the Constitutional Court. So it looks like there might still be quite a bit of time before this matter actually sits. But let's leave it there for now. Khuzeni, thank you so much for your analysis this evening. That's legal analyst Mpumelelo Zikalala.